Good morning, everyone. Hi, my name is Annette Yazzie. I'm an advocate here at Native American Disability Law Center. And today we have a presentation specifically on employment practices and accommodations. I have my Austin Moore, the attorney here at the Law Center as well. Austin, would you?
Sure. Good morning. My name is Austin Moore. As Annette said, I'm an attorney here at the Native American Disability Law Center. I'm a member of the Samish Indian Nation, and I also have ties to the Little Shell Chippewa tribe on my mother's side.
And I would also like to tell you that, or give you my, formally introduce myself in my language. She Annette Yazzie and Shne Tutna Sunny Bushishchind, touching the I'm sorry, touching the Bushishchind Tutna Sunny, Isabel Che Dashe Ado, Ashi Ada Chanela. Thank you for allowing us to present this presentation to you. We want to give you some information, some education around employment practices and accommodations for people with disabilities. So would you advance the slide, Austin? But first, I'd like to let you know that this webinar will be recorded and posted on our Native American Disability Law Center website, which the website and contact information will give you at the end of this presentation. Next slide. So who is the Native American Disability Law Center? We want to make sure and explain to you what we are about. So our law center provides advocacy, referral information, and educational resources to all Native Americans with disabilities. And our service area is in the Four Corners region. We also monitor facilities on the Navajo Nation, facilities like the group homes, detention centers, and to ensure that people with disabilities are provided with the services they need in the least restrictive environment. We also provide legal advocacy work and representation in disability-related discrimination in the housing, employment, education, and voting. Also, again, in the facilities that I mentioned before. We also provide advocacy and legal representation to Native students with disabilities in education-related issues. Those are specifically related to the Individuals Education Act, or IDEA. Next slide. So we have an overview of this presentation, and we want to make sure to let you know that we're going to be talking about the Navajo Nation's civil rights on individuals with disabilities, also on Section 504 and the Federal ADA, or the Americans with Disabilities Act, and give you a definition of what disability means when we say disability. We're also going to provide you some information around myths and facts about people with disabilities, and provide you some statistics. And these statistics are specifically for the Navajo Nation. And in the end, we'll provide you our contact information on how to contact us. Next slide. But before we start our presentation, we want to show a video about disability and employment in the employment context. So this video is also found on our website. Austin, would you click on that website? So before you do that, Austin, I just want to introduce this film introduces 7 people with disabilities who share their stories and journey. And this is in the pursuit of in employment and education. So would you go ahead and show that video or also show where people can find it?
Okay. Is our website showing?
Yes.
Okay.
Okay, so this is our website. And you can just click on the video there.
But if you wanted to introduce our website. Okay.
There we go.
Let me know if the audio levels are good when I start playing.
I'll give you a thumbs up, Austin, if it's good. There is no audio.
I think I might know. I think I remember doing this once and yeah, sure sound.
Here. It's hard for me to walk up and down the stairs.
Can you hear the sound now? Okay, I'm gonna restart the video. My apologies.
Applications are online only.
I don't have a computer or access to internet at home.
Well, then you can use the terminal at the top of the stairs here.
It's hard for me to walk up and down the stairs. Do you have a computer down here I can use?
Only on the second floor do we have public access. Other than that, I don't know what to tell you.
Okay, so how do I apply?
Karen, you can go online and print her an application if you want to.
Here you go. I didn't
Thank
know
you.
we could do that.
Thank you.
As a job applicant, you have rights. Did you know that laws prevent employers from discriminating against individuals with disabilities? The Americans with Disabilities Act, or ADA, is a federal law that protects people with disabilities in the context of employment and other areas. If you have a disability that substantially limits one or more major life activities, but you meet the requirements of a job, you are protected by the ADA. As with any job interview, you'll want to be prepared, professionally dressed, and on time. You'll want to be ready for the common questions asked on job interviews. Will your job interview be any different if you have a disability? Can the employer ask you questions about your disability? And are there questions you do not have to answer? Watch as Mary sits down for her first interview for a position as an accountant.
Hello, Mary. Thank you for coming in today.
Yes, thank you for making time for me.
So, Mary, if you could tell me a little bit about yourself, that would be so great.
Sure, my name is Mary Harrison.
The employer does not know that Mary has a disability, and she has decided not to share that information with the potential employer at this time. It is Mary's right and personal choice if she wants to disclose her disability. Let's continue watching to see examples of questions you may be asked.
Can you tell me about your educational background and your experience?
Yes, I took classes in cost accounting, financial management, and computer-based info systems.
And so, Mary, what's your health like? Is there any reason your health might keep you from doing your job?
Okay, the employer cannot ask any questions that would make the applicant reveal that she has a disability. Employers may ask about an applicant's non-medical qualifications and skills, such as the applicant's education, work history, and required certifications and licenses. This ensures that an employer makes a decision based upon an applicant's qualifications and not whether they have a disability. Here are some examples of other questions an employer is not allowed to ask. Do you have a disability? Have you been treated for any mental health problems? Have you ever seen a psychiatrist? Have you ever filed for workers' compensation? Do you have a heart condition? Are you on any medications? On the other hand, you should be prepared to answer questions directly related to your ability to perform the job. For instance, you may be asked, what education, skills, and training do you have that will help you succeed in this position? What certification and licenses do you have? What is your work history? They may even ask those dreaded interview questions like, what is your biggest weakness or what are your strengths? Let's see if this employer can ask a better question.
Have you had a chance to review the job requirements and feel you are able to do everything the job requires?
Yes, I can. I worked with my previous employer for 8 years as his accountant, doing the same kind of work.
That's a better question. Keep in mind that you should carefully review the job duties to make sure you are able to perform all the specific job functions. Even if you have a disability, you must be able to perform the essential functions of the job either with or without a reasonable accommodation. We'll talk about what a reasonable accommodation means in a bit.
It was good to meet you, Mary.
I appreciate your time. I look forward to working with you.
We're happy to say Mary got the job. Mary has a disability that limits her ability to walk up and down stairs or on an incline. When she arrived at her new job, she finds that she has to climb a flight of stairs to get to and from her office or to the office printer. So what does she do?
Hi, Mary. What can I do for you?
My workspace isn't working for me. I need some accommodations.
Okay. What accommodations are we talking about?
That probably wasn't the best way for Mary to request for a reasonable accommodation. However, if there is something about your workplace that is preventing you from performing your work duties because of your disability, you can ask your employer for a reasonable accommodation. A reasonable accommodation is a modification or an adjustment to a job or the work environment that will enable a qualified applicant or employee with a disability to participate in the application process or to perform the essential job functions. Some examples of reasonable accommodations are providing materials or instructions in alternate formats, like Braille or large print, modifying equipment or devices, like adjusting the height of a desk to accommodate a wheelchair or providing a computer screen reader, modifying work schedules, such as adjusting arrival or departure times or providing periodic breaks. You can request for an accommodation verbally or in writing, or even someone else might be able to make the request for you. Alternatively, an employer may ask you to fill out a form or submit the request in writing, but the employer cannot ignore the initial request. Really, you should ask for these changes as soon as you notice the problem and before your work performance suffers. Let's watch Mary as she makes the same request, but in an effective way.
I have a difficult time climbing up and down the stairs to my office. The filing cabinets and printers are downstairs, so it makes it really difficult for me to perform my job efficiently. If I had an office downstairs, it would really help me keep up with my duties. Do you think that would be possible?
So basically, you just want a ground floor office. The employees on the ground floor have been with me for years. They will be upset if I have to move one of them upstairs. And that one empty room I do have down there is used for storage. It's not even designed to be an office. Do you know how much that would cost me to build you your own office in that room? We are a small business. I've got 10 other people on the second floor who work just fine the way things are. and you want me to provide an office downstairs?
Well, that didn't go well. A common mistake employers make is to refuse an accommodation because it's too hard or may cost them. Reasonable accommodations are not nearly as costly as many employers fear. According to the Job Accommodation Network, JAN, a service from the U.S. Department of Labor's Office of Disability Employment Policy, 57% of accommodations cost absolutely nothing to make, while the rest typically cost only $500. Additionally, most employers surveyed indicated that their company had benefited financially as a result of providing job accommodations. We'll give the employer a second try at answering.
Thank you for letting me know about this, Mary. I had no idea how much difficulty you were having with these stairs. You know, I'm not familiar with the type of accommodations we have available, but we definitely want to work with you. Let me talk to Human Resources and see what suggestions they have.
Okay.
And in the meantime, we'll get Jerry to help run papers back and forth for you. Does that sound okay?
Yes, thank you.
We'll get back with you within 48 hours to let you know what may be available. And thanks again for telling me about this.
It's been 2 days since Mary talked to her employer. Let's see how things are going.
Mary, thank you for coming in. I talked to the Human Resources and they had some good ideas. We've talked to Emily in the office by the filing cabinet. She's going to move up to your office and let you have hers. We're also going to get a small printer for your desk so you won't have to get up every time you need to print a report. Would that help you?
Oh, that would help me so much. Thank you.
In the meantime, could you help us with one more thing?
Yes, what can I do?
Human Resources requires medical documentations that you have a disability and showing your physical limitations. Would you bring that to me within the next week?
I would be happy to. I'll call my doctor today.
Remember, as a job seeker, job applicant, or employee, you have rights. Employers cannot discriminate against you because of your disability. The law applies to all private employers with 15 or more employees, in addition to all state and local government and federal employers. The employer has to make the decision to hire you based on whether you are qualified to perform the job duties. If something about your work environment is preventing you from doing your job because of your disability, you have the right to ask for reasonable accommodations. That means that you can ask for changes to your work environment that would help you to perform your job. Remember, if you don't need an accommodation, you do not have to disclose your disability. Mary was applying for an accounting position, but the ADA covers many other jobs, like a cashier, produce clerk, construction worker, dental hygienist, office specialist, bus driver, and many more jobs. If you are an individual with a disability and are employed or seeking employment on the Navajo Reservation, you are also protected under Navajo Nation law. A resolution of the Navajo Nation Council, Civil Rights of Individuals with Disabilities Act prohibits employers from discrimination based on disability. If you feel you have been discriminated against in employment on the basis of a disability, please contact the Native American Disability Law Center. We can explain your rights under the Americans with Disabilities Act and give you the resources you need to succeed at your work.
Thank you for showing that video, Austin. I hope that video gives you a better idea of what, how or when, at what stage of an employment process, whether that's during the application process or if you're already an employee, and recognizing disability-related issues that might arise. So that video, again, can be found at our website at nativedisabilitylaw.org. Austin, would you advance to the next slide, please? So now I'm going to turn it over to Austin, who will give you more information about the specific laws related to this employment context. Austin?
Okay, thanks, Annette. So yeah, I think that video is a good video to give an overview of the sort of issues we're talking about today. I'm going to go into a little bit more detail about the same material that the video went over. So at the end of that video, discuss the Navajo Nation Civil Rights of Individuals with Disabilities Act. This act was passed in 2018. And in the act, it stated that in harmony with traditional and common law, it is the policy of the Navajo Nation to respect, revere, and protect all individuals, their communities, and their unique qualities. So now I'm going to provide a little bit of background about how that act came about. So on April 25th, 1979, the Navajo Nation Council approved the Navajo Affirmative Action Plan to ensure that Navajo individuals with disabilities have equal access to employment opportunities and to public buildings on the Navajo Nation. And the council adopted a plan of operation for the Navajo Nation Advisory Council on Disabilities. The Affirmative Action Plan was grounded on the premise that all persons should have an opportunity to realize their greatest potential to the extent of their mental and/or physical capabilities. And it directed affirmative steps to be taken by numerous Navajo Nation programs to ensure non-discrimination in hiring and employment and access for individuals with disabilities to all public buildings, private businesses, and public activities and services. So fast forward to 2005, the Navajo Nation Sovereignty and Education Act passed. The Navajo Nation Council included a section entitled Vocational Rehabilitation and Opportunities for Individuals with Disabilities, which directed all public and private entities to cooperate with the Navajo Nation Advisory Council on Disabilities and recognizing people with disabilities as potentially productive members of society, and in making reasonable accommodations to the special needs of persons with disabilities, including the need for site accessibility in regard to employment, housing, public accommodations, social services, transportation, recreation, educational and training opportunities, and community services, and assure the availability of these services on an equitable, non-discriminatory basis. In addition to the Navajo Nation Advisory Council on Disabilities, there are references in the statutes to both the Navajo Nation Advisory Council on the Handicapable and the Navajo Nation Council on Handicapped. The Navajo Nation Council found that all such designations are intended to refer to the Navajo Nation Advisory Council on Disabilities. On November 17th, 2014, Navajo Nation President Ben Shelley issued Executive Order number 14/2014, called Ensuring the Rights of Navajos with Disabilities to Full Access and to All Navajo Nation Buildings and Services. And while this executive order mandated that all Navajo Nation divisions, departments, enterprises, or entities shall develop, update, or amend current policies and procedures to ensure that services are provided in an equitable and non-discriminatory manner. Such agency action is far from complete, leaving individuals with disabilities vulnerable to policies and procedures that may lead to inaccessibility, discrimination, or both. The Navajo Nation Council found that despite the clearly stated policy and intent of the Navajo Nation to ensure that individuals with disabilities have full access to employment, housing, and public services, that goal has never been realized, and individuals with disabilities remain at a severe disadvantage in having full access to equal opportunity in all of those areas. The Navajo Nation Council found that the most likely reasons for that failure have been the lack of funding and clear authority of the Navajo Nation Advisory Council on Disabilities. The lack of that clear authority. The absence of mandatory directives to programs on the Navajo Nation, whether these programs be public or private, and the absence of provisions in Navajo law for the enforcement of the rights of individuals with disabilities. So finally, the Navajo Nation Council found that the most effective means of ensuring that individuals with disabilities are provided equal access to employment, housing, education, services, and buildings, be they government or private in nature, is to incorporate those rights into the Navajo Nation Code and to replace the existing code with more substantive civil rights in order to make the law both specific and enforceable. And this is what turned into the Civil Rights Act of 2018. So between both Navajo and federal laws, there's a lot of terms that share similar definitions. These acts are meant to be read sort of together with similar terminology and understanding. So I apologize in advance if it seems like I'm beginning to repeat myself a little bit, but hopefully today it helps you guys remember the common definitions and highlight what the key points are. So in the Civil Rights Act, it contains 4 main definitions that relate to one another. The Civil Rights Act defines disability as a physical or mental impairment that substantially limits an individual's ability to engage in one or more major life activity. So you might ask, what is a major life activity? Major life activities include things like performing manual tasks, caring for oneself, seeing, hearing, eating, sleeping, things like that. Other major life activities include the operation of bodily functions, such as functions of the immune system, cell growth, digestive, neurological, respiratory. So these are both related to physical and mental disabilities. Likewise, the definition is related to both physical and mental life activities. Both are included. The second definition is, or really the third definition, is reasonable accommodations. So the Act defines this as a necessary and appropriate modification, not imposing a disproportionate or undue hardship needed to ensure that a person with a disability is able to obtain access or participate in a particular right, benefit, or opportunity. So what is meant by undue hardship? So an undue hardship would be an action requiring significant difficulty or expense when considering the following factors: the nature and cost of the accommodation needed, the overall financial resources of the facility, providing the reasonable accommodation, which would include the number of persons employed at the facility, the effect on expenses or resources, or the other impacts on the operation of the facility. It also includes the overall financial resources of the facility, again, the size of the business, number of employees. And then it also factors in the type of operation, which includes the composition, structure, and functions of the workforce, the geographic separateness, or the administrative or fiscal relationship of the facility. So in other words, you can sort of think of this reasonable accommodation and undue hardship as a balancing test that compares the cost of the accommodation and the ability of the program to provide the accommodation with the requested accommodation. So how do we apply these definitions? So what evidence must be shown? What remedies can be provided? Again, you can kind of think of this like a balancing test or a pendulum. So to begin, the Navajo Nation Civil Rights Act requires that medical evidence is necessary to establish that an individual has a disability. Sources of medical evidence may include documentation from medical facilities, or they can come from traditional sources, such as the testimony of medicine men. An individual seeking the protection of the civil rights stated in the Civil Rights Act as an individual with a disability will have to demonstrate that he or she has a disability, as we defined earlier. Then once it's been established that an individual has a disability, like a pendulum, the ball swings the other way. So the denial of a request for a reasonable accommodation can only be made if the provider demonstrates undue hardship. So for an example, say a person provides their employer with a doctor's letter stating that he or she has a visual disability and requires that communication be provided in an accessible format, thus establishing a disability. The employer would then need to consider their resources available to provide this accommodation. Generally speaking, providing documents in Braille, large print, or other alternative formats are not considered undue hardships. But say if the request is something like the individual is requesting, like a helicopter to come pick them up, fly them to the office because he or she needs a ride, that might be an undue hardship. And I know that's a silly example, but I hope it kind of shows the balancing test and sort of case by case sort of analysis that goes into these determinations. As for remedies, any person injured in violation of the Civil Rights Act and their fundamental rights as a result of an action or failure to act may seek remedies for such a violation in the form of legal and equitable relief in the courts of the Navajo Nation. So individuals can actually bring actions to court if the Civil Rights Act has been violated. There was the provision I wanted to give more in detail from the Civil Rights Act that covers employment. I thought I had that pulled up, so I apologize. Give me one moment to find it. Okay, so specifically in the Civil Rights Act, section 4504 covers employment. So the act says that no person with a disability shall be denied selection for or retention in employment because of his or her disability, so long as reasonable accommodations can be made that will allow that individual to perform his or her employment duties. So again, that's section 4504 of the Civil Rights Act. So when you're looking through the Civil Rights Act, you might see that it might be a little short compared to a lot of the other laws, but it still contains a lot of key and important protections for individuals with disabilities on the Navajo Nation. So now we're going to transition into the federal laws. So the first one we're going to talk about is Section 504 of the Rehabilitation Act of 1973, which is a federal law that prohibits discrimination on the basis of disability and federally assisted programs or activities. So this could apply to employers that receive federal funds, but it also can include things like housing, education, and a lot of other programs and activities. Specifically, Section 504 states that no otherwise qualified individual with a disability shall solely by reason of her or his disability be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program, service, or activity receiving federal financial assistance, or under any program or activity conducted by any executive agency. So what this means is that Section 504 prohibits discrimination on the basis of disability in any program that receives financial assistance from any federal agency. So one point that often comes up is, does Section 504 of the Rehab Act or does the Rehabilitation Act apply in Indian country? The classic legal answer is it depends. Again, Section 504 applies to any program that receives financial assistance from any federal agency. So a private or tribally owned business on the reservation wouldn't have to follow Section 504. But for example, if a BIA school was hiring that receives federal financial assistance to operate or is operated by a federal agency, the school would then need to follow section 504. So let's go back to that definition I read earlier. No otherwise qualified individual with a disability. What does that mean? So similar to the Civil Rights Act, an individual with a disability is any person who has a physical or mental impairment that substantially limits one or more major life activities. So the term physical or mental impairment may include conditions such as a visual or hearing impairment, mobility impairment, but it also includes things like developmental disabilities, drug addiction in certain cases, or mental illness. Remember, these definite determinations vary case by case. So remember, none of these are hard, fast rules. For the second part, the term major life activity, again, includes things like seeing, hearing, walking, breathing. Remember, this list is not exhaustive. Section 504 also protects persons who have a record of such impairment or are regarded as having such an impairment. For example, say an individual undergoes treatment for cancer and then returns to work. Although the person may have recovered and the cancer is in remission, they would still have a record of having had it and would be entitled to Section 504 protections. On reasonable accommodations, a few questions that normally come up. What is a reasonable accommodation under Section 504? So again, these are a little repetitive. Reasonable accommodation is a change, adaptation, or modification to a policy, program, service, or workplace, which will allow a qualified person with a disability to perform the essential functions of a job. We'll go over what the essential functions of a job means in a second when we talk about the ADA. They sort of correlate together. But for now, just think of them as the main components of a job. For example, if you work out as a chef in a restaurant, the essential functions of the job are probably going to include things like being able to use kitchen utensils or being able to use an oven, keeping the cooking area clean, things like that that are the main aspects of the job. But remember, since persons with disabilities may have unique needs due to their disabilities, in some cases, simply treating persons with disabilities exactly the same as others may not ensure that they have an equal opportunity to perform their job roles. In order to show that a requested accommodation may be necessary, there must be an identifiable relationship, or what's called a nexus. So basically, there must be a connection between the accommodation and the individual's disability. And then what is reasonable must be determined on a case-by-case basis. However, there are some examples that are often found as reasonable accommodations. For example, an employee with a mobility impairment who has difficulty walking might be provided a reasonable accommodation, such as a assigned parking space in the front of the entrance to the office. Another example might be an employee with anxiety might be given an office placement or a workstation that is away from distracting or noisy hallways. Another example might be an employee who uses a wheelchair might have difficulty picking up items off the ground. So they might be allowed to have an assistance animal that fetches things for her as a reasonable accommodation to their disability. So again, how do you determine whether a request for a certain accommodation is reasonable? It's going to be provided on a variety of factors that must be decided on a case-by-case analysis. So in the 504 context, the determination for a requested accommodation depends on the answers to two questions. First, does the request impose an undue financial or administrative burden on the employee? And then second, would making the accommodation require a fundamental alteration in the nature of the employer's operations? If the answer to either question is yes, then the requested accommodation is not reasonable. So again, if it imposes an undue financial burden or requires a fundamental alteration in the nature of the operations, it might be unreasonable. But if not, then it might be reasonable. Okay, moving to the Americans with Disabilities Act. So the ADA came later. It was passed in 1990. It was passed to expand the protections to people with disabilities much more broadly than the Rehabilitation Act did. So the ADA, instead of just focusing on federal financially assisted programs, the ADA has multiple titles covering things such as public accommodations, state and local governments, but we're going to focus on Title I of the ADA, which covers employment. But first, quick dip into some federal Indian law. Under federal law, tribal nations, as domestic nations, enjoy sovereignty and tribal immunity. Thus, tribes are largely exempt from the ADA. But tribes are free to pass their own disability laws, as we talked about with Navajo Nation. They pass their own disability law, or some tribes have even adopted the ADA, such as the Oglala Sioux tribe of South Dakota. They passed the ADA as written in 1994. In these cases, the Oglala Sioux tribe is not bound in a similar fashion like states and local governments. So their tribal government actually implements and enforces the ADA independently as the federal government would. So under Title I, covered entities cannot discriminate against workers with disabilities in employment. So as I was discussing earlier, Indian tribes are explicitly excluded from the definition of employers. However, Title I does not exclude private employers located within Indian country. So the ADA requires Title I complaints to be filed with the Equal Employment Opportunity Commission. This varies between individual tribes. Tribal law may permit legal remedies for disability discrimination in tribal governments. Tribal members should consult with tribal laws of their individual tribe on whether legal remedies for disability discrimination are available. So these are pretty complex issues that we don't really have to get into today. I just wanted to give a little bit of background. But if anyone has specific questions about whether the ADA applies in certain cases, I can provide my email and you guys can shoot me an email as well. So now I'm going to give a brief rundown of the ADA protections, which are, again, very similar to the Rehabilitation Act. So Title I of the ADA largely defines people with disabilities the same way. So who is a qualified individual? Qualified individual is a person with a disability who, absent the disability, is otherwise qualified for the job. Now here, we'll talk about the essential functions of the job. So the way the ADA defines the essential functions of a job, it refers to the fundamental duties of a job that must be performed with or without reasonable accommodations. So the basic rule of thumb for essential functions of the job is that someone with a disability needs not to be qualified to do everything a job requires, but only those essential functions that are at the heart of the job. And then again, it discusses reasonable accommodations and undue hardship in the same way. So to save you guys from me repeating the same definitions over, I think I'm going to stop there and pass it back over to Annette.
Hi, everyone. I'm back. Wow, thank you, Austin, for that information. I think correct me if I'm wrong, but I gathered from that presentation that thank you for pointing out that disability, the definition of disability. Although there are various definitions that they should all be read together to enforce these disability laws, and also recognizing that what is a reasonable accommodation. Really, there's no hard rule that points out that yes, it is reasonable, and no, it's not reasonable. But it's based on several factors that come into play, making it the case by case recognizing that you have to point out these list or look at these factors to determine whether it's reasonable. And the last takeaway that I got is that while the federal law, ADA law, applies to all state and federal governments, that the ADA does not apply to all tribal nations, and that it is upon the tribal nations that would have to implement those specific disability-related laws for their tribal communities. As you pointed out, I think you said the Navajo Nation and the Oglala Nation in South Dakota have enforced some disability-related laws. So just wanted to point that out. That's all. I found it fascinating. So now I would like to change gears and talk more about some numbers, statistics, and myths surrounding disability in the employment context. So I have some questions here that I hope that gives you some insight and more knowledge and education. So I have the question here. So these questions were specific to a presentation of where we were expecting a large audience, but I think that it could still be applied here. So this is some sort of training. I hope that you could be able to answer at the end of our presentation. If someone asked, or you could even recognize that you now have received some sort of training on federal disability-related laws, and you can confidently can answer, yes, I have received some training after our presentation. So next slide, Austin. Austin also pointed out this specific section or number of the Rehabilitation Act several times. So I hope that after this presentation, you can just recognize and point out the specific number or section of the law. So the question is, what section of the Rehabilitation Act of 1973 prohibits discrimination based on disability in all programs or activities operated by recipients of federal financial assistance? And the answer to this is Section 504, and Austin pointed it out or mentioned it several times. So I hope that you recognize Section 504 of the Rehabilitation Act. Next slide. Here we have a statistics, and the question or the statistics is in March of 2017, the unemployment rate for people with disabilities was 4.3%. And so the question and answer to this is what is the unemployment rate for people with disabilities? And the answer to this question is 10.6. Next slide. Now I want to talk about myths on in the employment context and in employing people with disabilities. So here's a myth. Accommodating workers with disabilities costs too much. So I also want to point out here the fact, actually, reasonable accommodations is usually far less expensive than people think. In most cases, an appropriate, reasonable accommodation can be made without difficulty and at little or no cost. Next slide. Here's a myth. The ADA requires extensive renovation of all state and local government buildings to make them accessible. And this is, I think it might be neither, but let me explain, or it'll be definitely false. And the ADA requires all government programs, not all government buildings to be accessible. And that's the fact to this myth. Next slide. Here's the question: when can an employer ask any disability-related questions and conduct medical examinations? So if you recognize here, I have underlined various stages of the hiring process. So the answers are, as long as you do this for everybody in the same job category and during the job interview. The second question is at time of job application. And the last one is after the job offer. So the answer to this one would be C, after the job offer, is when an employer can ask about your disability and ask you about your medical, if they need any medical exam questions answered. Next slide. Here's an example of the medical examination. So if you want to give a medical examination to someone who has been offered a job that involved heavy labor, you must give the same exam to anyone who is offered the same kind of job. Next slide. And Austin went over this reasonable accommodation topic extensively. So I think that we can easily gather the answer from these choices here. So what is a reasonable accommodation? It is a modification or an adjustment to a job or the work environment that will enable a qualified applicant or employee with a disability to participate in the application process or to perform essential job functions. And B says it's an adjustment to ensure that a qualified individual with a disability has rights and privileges in employment equal to those of non-disabled employees. So the answer to this one is both A and B. If you recognize here the various individuals in A, there's a qualified applicant and an employee, and the choice B recognizes that this is a person who's already an employee. So the answer to this would be both A and B. Next slide. Which of the following are examples of reasonable accommodations that may be needed during the hiring process? So A says providing written materials in accessible formats, such as large print, braille, or audio tape. B is providing readers or sign language interpreters. C, ensuring that recruitment interviews, tests, and other components of the application process are held in accessible locations. D is adjusting or modifying application policies and procedures. I think, Austin, maybe you could chime in on this one here. I think the answer, this one is a bit tricky, I think, but I think it is all of the above. But I also think it might be only A, B, and C, because I'm saying all of the above because they're all related to the stage of the hiring process. What do you think, Austin?
Right, I think you're right. And I think this question, it's important to remember that reasonable accommodations is a very case-by-case analysis. So as you're looking at D, adjusting or modifying the application policies and procedures, if it requires a fundamental alteration of some of these policies to where you're really changing the nature of the job, then it might be unreasonable. But if it's just making some slight modifications, say the application policy says you must turn in your application in writing, an accommodation might be able to be made to that application to be able to do it in person, or to get assistance, or to do it in a more accessible format. So yeah, I think it may or may not be all of the above or only A, B, and C. It just really depends on the specific facts of the scenario.
Okay, thank you for providing your information about that. Could you advance to the next slide? So what is an undue hardship when providing a reasonable accommodation? And I heard the answer in Austin's presentation earlier. And for this one, it is going to be selection A, because it's talking about the significant financial burden on an organization. And B, it is when an organization is not able to provide reasonable accommodations and must deduct the expense from the employee's paycheck. I think this answer is just, it just seems unfair that the employee would have to pay for the accommodation. And then C, there's no exception. The organization is required to provide a reasonable accommodation. That also, I think, is just does not seem fair as well. So I think that the answer would be A. So an undue hardship would be a significant burden, financial burden on the organization. So the answer to this one is A. Next slide. And this question or statement would be a fill in the blank. So employees with disabilities have a lower, equal, higher absentee rate than employees without disabilities. So the answer to this one is employees with disabilities have an equal absentee rate than employees without disabilities. Next slide. Persons with disabilities are an employment risk because they cannot meet performance standards, have lower performance standards than others without disabilities, will need to be evaluated based on their disability, or D, not an employment risk because employees with disabilities rated average or better in job performance compared to other employees without disabilities. The answer to this one is D, not an employment risk. Next slide.
Just a real quick point on this one. So in 1990, DuPont conducted a survey of 811 employees with disabilities and found, like Annette said, 90% rated average in job performance compared to 95% with for disabilities without employees. A similar 1981 DuPont study, which involved 2,700 employees with disabilities, found that 92% of employees with disabilities rated average or better in job performance compared to only 90% of employees without disabilities. And then the 1981 results were comparable to a 1973 job performance study. Just wanted to share those numbers.
Okay, here's a related fill in the blank. Employees with disabilities have higher, identical, lower accident rates on the job than employees without disabilities. The answer to this one is identical. Employees with disabilities have identical accident rates on the job than employees without disabilities. Next slide. Here's a question. Should employers ensure that employees with disabilities have more protection from failing? And the answers are no. Persons with disabilities have a right to participate in the full range of human experiences, including success and failure. B, no, employers should have the same expectations and work requirements for all employees. Or C, yes, people with disabilities should be held to lower job performance standards. That just seems like not the answer. So the answer would be A and B. Next slide. And we have our last myth here. All people with disabilities require job accommodations. That is false. In fact, the ADA, under all people with disabilities require job accommodations is not true. Studies have shown that less than 1/4 of employees with disabilities need accommodations. So related to myths, myths are roadblocks that interfere with the ability of persons with disabilities to have equality in employment. And these barriers usually result from lack of experience, interaction with persons with disabilities. And this lack of familiarity has nourished negative attitudes concerning employment of persons with disabilities. So it's important to learn the facts to remove these roadblocks or barriers to stop discrimination. Next slide. And now I'd like to allow Austin to talk more about the statistics specific to the Navajo Nation. Austin?
Thanks, Annette. So here we have a few stats. So from ages 21 to 54, 29.9% of Navajos have a disability, which equates to over 25,000 individuals. 70% of Navajos over the age of 64 have a disability. In 2015, the overall percentage of people with a disability of all ages in the US was 12.6. And then 17.7% were Native Americans reported with a disability. And then, according to a detailed analysis of the 2000 census data of Navajos, 25% between the ages of 16 to 64 years old have a disability. 14% of Navajos with disabilities have a college degree or are enrolled in graduate school. And 64% of Navajos with a disability between the ages of 21 to 64 are unemployed. And then here the Navajo Nation unemployment rate in 1990 was 27.9%. In 2001, it was 42.16%. In 2007, it was 50.52%. And in 2011, it was 47%. And then as compared in 2017 to Arizona's 6.2%, 6.8% in New Mexico, and 3.1% in Utah. And then some stats here. Navajo Nation employer status. There's 800 employers on the Navajo Nation. Can't see these. 53% were non-Navajo owned, 27% were Navajo owned, and 20% were government offices. And back to you, Annette. You're muted, Annette.
So we would like to just hope that you share this video if you're wondering about disability-related laws in the employment context. If you're a person that feels that you've been discriminated against in the employment context, you can contact our law office here by calling this 800-862-7271 number, or you can go to our website to find this specific recorded video, and more information and resources at nativedisabilitylaw.org. We do have 2 locations. Our main office is in Farmington, New Mexico, and we have our Flagstaff office. If you have any questions, Austin, would you like to leave your information? You're muted.
I'm muted too now. Sure. I'll write it in the chat here, but you can email me at my email is amoore, so AMOORE at nativedisabilitylaw.org.
Well, that concludes our presentation. Thank you. And they can have.
Thank you.